My name is Rutuja Prakship Raut. Subject is labor laws and implication. Topic is Industrial Relation Code. Industrial Relation Code 2020. Code states that the provision for standing order will be applicable for every industrial establishment wherein 300 or more than 300 workers are employed or were employed on any day of the preceding 12 months, and increasing in a threshold for requirement of a standing order. Rules of conducting for workmen employed in industrial establishment to over 300 workers from 100. This implies industrial establishment with up to 300 workers will not be required to furnish a standing order. 16 states had already increased the threshold for closure, layoff, and retrenchment in firm with up to 300 workers without government permission. Code also introduced new conditions for carrying out a legal strike. The time period for arbitration proceeding has been included in the condition for workers before going on a legal strike as against only the time for conciliation at present. A worker cannot go on strike out providing at least a 60-day notice and not while proceeding before a tribunal or a national industrial tribunal are taking place. After the conclusion of this proceeding, workers are disallowed from going on strike for a period of 60 days. The code has been expanded to cover all industrial establishment. Code has expanded to cover all industrial establishment for the required notice period and other conditions for a legal strike. At present, a person employed in a public utility services like water, electricity, natural gas, telephone, and other essential services cannot go on strike unless he gives notice for a strike within 6 weeks before going on strike or within 14 days of giving such notice. But now the Industrial Relation Code is applicable to all the industrial establishment. Framework to protect the right of workers to form union, to minimize the friction between the employers and workers, to provide provisions for investigation and settlement of industrial disputes. The definition of strike amended to mass casual leave. If over 50% of a company's workers take concentrated casual leave, it will be treated as a strike. However, workers cannot go on strike without a 60 days of notice. Occupational Safety, Health and Working Condition Code 2020 consolidate and amend the laws regulating the occupational safety and health and working conditions of the person employed in an establishment. The Act replaces 13 old central labor laws. Occupational Safety, Health and Working Conditions. The Factories Act 1948, the Plantation Labor Act 1951, the Mines Act 1952, the Working Journalist and Other Newspaper Employees Act 1955, the Working Journalist Act 1958, the Motor Transport Workers Act 1961, the Bidi and Cigar Workers Act 1966. The code defines a migrant worker as someone who has come from his or her own state to seek employment in another state and who earn up to rupees 18,000 per month. About definition is an expansion of the current definition adding those workers who are directly employed to those contractually employed. Occupational Safety, Health and Working Condition Code 2020. Registration, duties of employer and employees. Occupational safety, health, working conditions, hours and work and annual leave with wages are defined. Special relating to employment of women are enacted. Special provision for contract labor and interstate migrant workers are introduced. Prohibition of employment of contract labor is given. Prohibition of employment of audiovisual worker without agreement. Employment of person below 18 years of age is mines are provided. Earlier provision for temporary accommodation for workers at or near their work site is replaced with a journey allowance to be paid by the employer that enables a worker to travel between his native place and the site of employment. Women employees will be permitted to work at night subject to certain conditions that relate to safety, holidays, working hours, and their consent. The Code on Social Security 2020. The Code to amend the consolidate the laws relating to social securities with the goal to extend social security to all employees and workers either in the organized or unorganized or any other sector. The Employees Compensation Act 1923, the Employees State Insurance Act 1948, the Employees Provident Fund and Miscellaneous Provision Act 1952, the Employment Exchange Act 1959, the Maternity Benefit Act 1961, the Payment of Gratuity Act 1972, the Sign Worker Welfare Fund Act 1981, the Building and Other Construction Worker Welfare Cess Act 1996, Unorganized Workers Social Security Act 2008. Appeal to Tribunal, determination and assessment of dues, order of the appealed authority, determination of escaped amount, levy of damage. Employees State Insurance Corporation, Constitution of Employees Insurance Code, matters to be decided by EI Court, powers of EI Court, proceeding of EI Courts, appeal to High Court within a period of 60 days from the date of the order. Payment of gratuity, payment of gratuity. Payment of gratuity after rendering continuous service for not less than 5 years. Continuous service defined, facility of nomination, determination of amount of gratuity provided, provision compulsory insurance, establishment of component authority. Maternity benefit. Employees of or work by women prohibited during certain period. Right to payment of maternity benefit. Fixing duties of employees. Power of inspector cum facilitator to direct payment to be made. Employees compensation. Compulsory reporting to the component authority within 7 days of the death or serious bodily injury. Employer's liability for compensation is fixed. Method of calculating monthly wages for purpose of compensation is provided. Periodic review of a change in the condition of the employee for purpose of continued increased decreased payment. Notice and claim within 2 years of the occurrence of the accidented or in case of death within 2 years from the date of death. special provision relating to accidents occurring outside Indian territory, masters of ships or seamen or captain or other members of crew of aircraft, person recruited by companies registered in India and working as such abroad. Employees compensation, remedies of employer against stranger, insolvency of employer, power to require from employer statement regarding fatal accident, registration of agreements, reference to co- competent authority. Form of application for claim or settlement, provision for power of competent authority to require further deposit in cases of fatal accident. Power and procedure of competent authority is defined. Compounding of offenses. Any offense committed for the first time, not being an offense punishable with imprisonment only, or with imprisonment and also with fine, may on an application made either before or after the institution of any prosecution be compounded. Failing to comply with the order attracts additional fine for a sum equivalent or 20% of the maximum fine provided for the offense. Thank you.